But just want to thank everybody for coming tonight and joining us. For those of you that don't know me, I'm Michael Karnakia, Portfolio Manager, Senior Wealth Advisor, and Managing Partner of 6 Point Wealth Management. I'd like to welcome you to our first installment of our education series that is designed to empower you with knowledge and the need for sound financial planning. We're going to look to have many of these sessions coming in 2024 as well. At 6 Point Wealth, we believe it's important to educate you, our clients, and to empower you with the knowledge and understanding necessary to make informed financial decisions, foster a sense of financial literacy, and confidence in navigating your personal financial landscape. In our first session today with ClearEstate, our estate planning partner, they're going to shine a spotlight on estate planning 101. Today, from ClearEstate, we have Ellie Muir, a key account manager, and she is our relationship manager and first line of contact at ClearEstate. We also have Sarah Hillier, Senior Director, Estate Planning and Settlement. She has extensive knowledge and experience in estate planning and settlement and is a trust and estate practitioner. She'll be the one speaking to us today about estate planning. Just a little bit on ClearEstate. Their mission is to empower estate executors by delivering transparent estate settlement solutions through highly trained professionals and state-of-the-art technology. Settling a loved one's estate can be emotionally draining, time-consuming, and even expensive. Heavy reliance on lawyers and accountants can add up quickly and not only eat away a sizable part of a loved one's estate, but also add confusion and stress during a very difficult time. At ClearEstate, they support families by completely removing estate administration from their concerns. Having a comprehensive estate plan is one of the most valuable gifts you can give to a loved one after you're gone. Thoughtful planning is not only ensures that your wishes will be honored, but it will also result in significant time and financial savings and great reduction in stress for your loved ones when the time does come. So in today's webinar, we're going to be covering a few things here. One, we're going to take a detailed step-by-step overview of the estate planning process. We're going to talk about some of the most important things to consider when you are looking at your estate. We'll also look at some common oversights and how to avoid them, and also the difference between a will and an estate plan, and why having only a will isn't just enough. So at this point, you aren't here to listen to me, so I'm going to hand it over to Ellie and Sarah to get us started this evening.
Thanks so much, Mike. That was excellent. I really appreciate the thorough introduction to ClearEstate. Hi, everybody. Thank you so much. I'm sorry we started a little bit late today, but I see there's a nice big group here, so we're excited to present to you. As Mike said, I'm the key account manager. I'm one of the first people that you're going to meet when you engage with ClearEstate to talk about how we can help you, whether it's for settlement or for estate planning. And lucky for you tonight, we have our senior director, Sarah Hillier, and she's going to go over estate planning 101. I'll just remind everybody that as she's speaking, feel free to put your questions in the Q&A box at the bottom, and we'll reserve some time at the end to get those questions answered for you. So take it away, Sarah. Thanks.
Thanks so much, Ellie and Michael. Appreciate the warm introduction. Without further ado, we'll dive right into the main contact. Michael already touched on what our kind of outcomes are for you guys today, but we'll start with sort of the lay of the land of what exactly an estate plan is, which will help you understand why you need one or reinforce if you already have one. Now, the simplest definition is really arrangements for what happens with your assets when you pass away. And I will also add if you were to become incapacitated. Both of those being very important, of course. Now, the actual documents that are typically involved are a will, of course. That's definitely, the primary or core document involved in an estate plan. I always emphasize that it needs to be legally executed and properly executed according to the rules in your jurisdiction. And then you have a power of attorney for property, which is for where you're incapacitated to deal with your financial assets or your all of your financial matters, and your power of attorney for personal care, which deals with things to do with your health care and things like that. The healthcare directives goes a step further for folks who want to give specific instructions around end of life care or different things. We certainly do see this more and more. In 2023, people have specific wishes around their healthcare. And then a living trust, which I won't go into detail today, but in some situations, it may be applicable or worthwhile to set up a living trust as well. Now, the reason why we do estate plans is really in order to develop efficiencies and savings and to customize for your family's circumstances and goals. What are your specific needs with relation to your estate plan? And then, of course, probably most importantly is actually simplicity for your loved ones. And I'm going to emphasize here that a lot of times people think that it's complicated to create an estate plan, but in fact, it's complicated to not have one. It's complicated to your family. It's complicated to your sort of well-being. If something happened to you, makes things more complicated to not have an estate plan. So with that, we're going to go through step by step what the estate planning process typically looks like. And I'm going to highlight for you some of the kind of do's and don'ts of each step in the process. So the number one thing that I would always suggest is that you consider seeking professional guidance. And I think the reason that I put this first is really because you don't want to go too far down a path that maybe doesn't even apply to you. And sometimes you don't know that unless you're looking for help early on, right? You do want to definitely consider specialists, as estate planning is, I would say, a specialized area, both in law and in finances. And so you do want to seek out professionals who deal with this stuff like every day, right? Or at least the predominant kind of area of their practice. There's a lot of lawyers out there who kind of dabble in estate planning, but it's actually not the core area of their practice. And so sometimes that's something you should keep in mind. You do absolutely want to be able to make informed decisions, and obviously professionals are going to be able to help you do that. Some don'ts that I think are important to note, certainly don't take advice from just anyone. And that's not to say that, people can't give you good tips for your consideration, but I wouldn't simply take advice and then apply it, to yourself broadly. And this actually is quite a common oversight in estate planning, is that people have heard something maybe from a colleague, a well-intended, colleague or friend or family member, about something that they did in their own estate plan. And they said, oh, my advisor told me that this is so great and, you should do it too. So it's important that you actually, don't do that. And you need to sit down and think about you and your circumstances. This last one is a really big one, because I do find that most of the families that we support, estate planning is in reality overwhelming, because you need to think about all the different pieces of things. You need to think about your family and like their situation as well, in addition to your own. And then you need to kind of learn some technical information in order for you to make informed decisions. So it can be overwhelming. What we try to do at ClearEstate is sort of break things down step by step so that things are not as overwhelming. But however you're going about getting your estate planning done, I would encourage you to do it in bits and pieces and not give up. The second step is really compiling all the pertinent information and documents. And when we do that, we always encourage you to be thorough. Leave no stone unturned, because when your executor has to go to deal with your estate, they're going to need access to everything, right? And that means, everything. Some stuff is obvious, right? The title to your real estate, your bank account information, your investment account information, but some things are maybe a little bit less obvious, like, how will they access your computer? Do they need a password, right? Do you have an iCloud account? Do you have a safety deposit box, and do people know that it exists? Where's the key, right? All of those different things are important to kind of compile that information, because you're doing this so that you can create a plan that makes sense, but you're also doing this to lay everything out for your executor. And so it's important to think through all those things and not to overlook anything. One thing I see people commonly overlook is, like, if they have some type of either a digital asset like cryptocurrency, or maybe like some sort of timeshare, and they just didn't think it was important. However, it is relevant and important, and you do need to plan for it in your estate. So don't overlook anything, essentially. And also think practically and about the actual access that people will have. A ton of times people can't access their loved one's phone after they've passed away, right? Because they don't have a passcode, and legislation is not really caught up with, modern technology. So, they don't easily give out they don't easily allow people access to devices. So all of those things need to be thought through. What I would say you want to make sure you don't do in this step is forget about the sentimental value of things. And in particular, things that don't necessarily have monetary value, but maybe it's photos, right? Maybe it's albums, like photo albums, or even framed photos, or, your degrees, or your things, medals, or, trophies, or different things that might be meaningful to family members. Obviously, sometimes there's collectibles or heirlooms, or even something that may seem trivial to you could be really important for your family. So don't forget about those things too. I would say don't assume it will be dealt with. This does happen often, particularly with personal effects, that it's kind of there's no specific instructions, and then it's sort of just up to people to figure out what to do with it. Or it has to be divided the same way as the balance of the estate, and then that can become more complicated than you actually intended, because one child is insisting they want this and another child wants that too. And so I would just encourage everyone to not assume that it will just kind of resolve itself, or everyone will just sort it out. It may not be setting them up for success. I already mentioned this, of course. Don't leave any stone unturned. The next step, I would say, and I mean, all of the steps are important, but I would say this is a big one. And I think this is actually often overlooked. You need to consider your goals and also your beneficiaries. And by that, I mean, you have to think about what's right for you, not necessarily what's right for others. In contemplation of your beneficiary circumstances. So, for example, if you have kids, what's happening in their lives? Is everything, okay in their relationships? Do they have, are there any beneficiaries with disabilities? Are there any beneficiaries who have any other like vulnerabilities? Are there addictions that we're dealing with, or are there different things going on in your beneficiaries' lives? Are they maybe going to get a divorce? Different things like that. Are they in kind of a high risk type of profession where they may be sued? All of those things are sort of important. A big one is lots of older wills say, because it was kind of once upon a time, the sort of standard was like, as soon as my kids turn 18, then they can have their share kind of outright. But I mean, 18 in 2023 is quite young. So is that really right? Should they receive a lump sum at the age of 18? In terms of financial maturity, it may be too young. So those are the types of things that you need to kind of think through. What are your goals? Do you want to have some protections that you want to think about? And then, of course, prioritize your goals, because sometimes your goals will naturally compete with each other when you're doing your estate plan, right? If you're prioritizing maybe a saving strategy versus, maybe keeping things simple type of strategy, or, being able to pay for estate debts versus making sure you minimize probate fees. Sometimes goals can compete. So you want to make sure you actually have a bit of a sense of prioritization. I would say what you don't want to do is allow others to dictate matters. Unfortunately, this does happen quite a bit, depending on family dynamics and personalities. Sometimes certain family members can get maybe a little bit railroaded in terms of how things should be done. And I would encourage, everyone to be cognizant of that and make sure that, you're the one who's in control, because these are your decisions to make. And certainly don't overlook any of your loved ones' circumstances. All of it is important in the context of your estate planning. This last one, don't assume everyone will understand. I think, later on, we talk a little bit about family meetings, but this is kind of what I'm getting at here, is that, communicating your goals for your estate plan to your family members can actually help them to understand and respect your wishes when the time comes. And I don't think that we can assume that they will understand simply because it is your right to dictate how you want to distribute your estate. However, bringing them into the loop can certainly help. So the next step is choosing your representatives. Again, another important step. I'm going to say they're all important. So that's not going to be particularly helpful. But when you're choosing your representatives, and when I'm saying representatives, I'm referring to the executor of your estate, who's going to be responsible for administering your estate. They're going to take charge of things after you pass away, and they're going to need to act prudently and, with a, impartially and in the best interest of your estate. If you're going to have a power of attorney, and you're going to also need to have a power of attorney for property, power of attorney for personal care. If you do establish trusts in your will, you need a trustee for the trust that's going to manage the trust on an ongoing basis. And all of those, if you have minor children, you also will be appointing a guardian if something happens to you while they're still minors. And so when you're choosing all these various representatives, it's important that you select them wisely, of course, and consider in detail, like what's involved in the role and are they the right person for it. So there's no real default who you should choose. It's more a matter of, for you personally, and who you have in your life, who's appropriate, right? And in some cases, a professional can be involved, but otherwise, generally speaking, you want that person to be trustworthy and able to carry out the duties involved. Really, really, really important. They need to be informed, not only of the fact that you're going to be appointing them in that capacity, but also like they need to know what's going to be involved. And most of the time, people actually don't. So a lot of the times, a surprising number of times, people actually don't even know they're appointed as executor until after their loved one passes away. But even for the ones who do know that they're appointed, they actually have no idea of what's going to be expected of them in that role. And I think that that's really important, because actually they should agree to act in advance. They should be comfortable with it and what's involved. It's really important. No one can be compelled to act, right? So they can't be forced. If they don't want to, they don't have to, right? So they should actually know about it in advance, know what it's involved in, agree to it. I always say don't just follow the status quo, because in my experience, I do find that a lot of folks will appoint an executor based on kind of their sort of, I don't know, maybe like what's been passed on to them, because maybe they were appointed as the executor for their parents and they're an eldest child. So then they appoint their eldest child. We see a lot of eldest children getting appointed as executor. And I think it's important to challenge that, because maybe the eldest child is the most appropriate person, but maybe they're not, right? I would say that a lot of considerations around this have to do with that person's personality, right? Are they going to be able to, navigate legal matters, tax matters, financial matters? Are they going to be able to kind of handle the stress of reporting back accounting to other family members, which can be very challenging, especially when emotions are kind of charged, when you're grieving? All of those things need to be taken into consideration. Are they, the kind of people that will, embrace paperwork? Because there's definitely lots and lots of paperwork involved. All of those things need to be thought about carefully. Definitely don't underestimate the power of your POAs. A lot of times in an estate plan, powers of attorney can be kind of almost an afterthought. And that's, you don't necessarily, you want to maybe think those through carefully, because the reality is, if you appoint the wrong person as your power of attorney for property, it may not, they may actually not leave your estate in a good position, and then your executor has to try to figure it out, right? So before things even get to your estate, you could have problems there. So that needs to be thought through carefully as well. Definitely don't assume everyone will get along. I have seen too many times of, unfortunately, it's really hard, even in the best of circumstances with families that, get along great, like dealing with the loss of a loved one is really difficult, right? So, and then dealing with estate administration, which is typically new. I mean, most people only deal with it once or twice in their lives. If they're lucky, then, it's really hard to get through it. And especially when, old feelings kind of start rising to the surface, siblings or family members, and things can really get out of hand quickly. So it's important that that piece is thought through in your estate plan as well. Okay, estate planning process, the next step, considering strategies. So now that you've kind of compiled everything, you have a lay of the land of, you've thought about all your assets, you've thought about all your beneficiaries, you've thought about who should be the appropriate representatives. Now it's time to kind of sit down and think about, okay, how do I want my estate to be distributed, and how can I create savings? How can I create efficiencies? How can I, make my estate settlement as efficient as possible, right? And I think considering probate savings is definitely a big one. It's not the only thing that's important, of course, but probate savings is definitely something to think about. Is there a way to, structure the ownership of assets, or, use beneficiary designations and things like that to create probate savings, which leads me to my next one, which I always caution people to be careful with beneficiary designations, because when you name a direct beneficiary, while it will mean that those funds are going to go directly to them, it also means that those funds, are not going to your estate, and therefore, are not available to pay estate debts and liabilities. And so you have to think about that piece too. Considering trust planning is definitely something that can be relevant for you, depending on, your beneficiaries and their circumstances and what your goals are. But these are all really key pieces of your kind of strategizing for your estate plan. I think it's important to not only think about the money, although obviously we all would like to see everyone save money where possible, particularly when we're talking about taxes and, court fees and things like that. But accomplishing your goals is not always only about money, right? It's also about protecting your loved ones and making sure that your family members are going to be set up for success. I think another one that's important is, many people are surprised to learn about the various debts and liabilities, particularly tax liabilities that come about after you've passed away. And so it's important to kind of know where you're directing your assets, either because there's joint owners or you have a beneficiary designation, or maybe you want your assets to go directly to someone, be transferred to someone. like you need to think through, is there liquid assets in your estate to actually pay for its debts? Otherwise, your estate may be left insolvent. And of course, you want to plan properly for that event. This on the same kind of line of thinking is, of course, like, don't forget about any liabilities. The vast majority of people that I speak to estimate their net estate value without actually calculating liabilities. So it's not actually the net estate value. So because they haven't factored in capital gains taxation, and things like that, which is typically the biggest, piece of potential tax liabilities in your estate. So super important that that's actually kind of mapped out for you. Now, understanding how everything fits together is, I think, important because you want to think a lot about right now and think a little bit about the future. And most of the time, people do the reverse and they think about the future state of their finances, or they think about the future state of how they want things to go, and they don't actually plan enough for the way things are today. So it's important that, like, a good estate plan actually has is planned for if you were to pass away tomorrow, but has enough contingencies for if things will change a bit for you in future. Definitely you want to map it all out. And like what we typically do with clients is actually, show them a visual of their distribution of how that will actually look for them, and factoring all of the different pieces in. And that way you can really see if the plan makes sense to you, right? Or are there any gaps or deficiencies that you want to think about? Definitely when we talk about understanding how everything fits together, it's really important that nothing is kind of planned in isolation, because this is where we could get into trouble, right? Where you've done something, on one particular account because maybe you thought, or somebody suggested to you this would be effective for probate savings, but then you didn't think about the impact that has on your overall plan. And we actually see this more in situations where, somebody's done a beneficiary designation, but they didn't think about how that would reduce a portion of the estate for other beneficiaries that were, inheriting from the estate directly. So the other thing that is, I think, really important, that I do like to emphasize a lot is, don't fail to align moral and legal obligations. And by that, I mean, don't put expectations on your loved ones that they will carry out things that are not actually, documented and prescribed under, your either your will or by law, because it really may set things up to unfortunately cause a world of trouble. And I'll give you a good example that I see all the time is, a parent will name one of their children as a joint bank account holder, and their expectation is that they will split that account after they die with their other siblings. But then, if that's not actually documented that way, and, if I think, people do this because this will avoid probate and it'll give them immediate access to the cash. But the problem is when they go to the bank and the bank simply says, okay, it's your account now, the reality is they may or may not actually, divide that account with others, right? And I don't want to assume anyone would do anything, purposefully, but if they're told the account's supposed to be theirs, then they may just believe that, right? So I think it's really important to be abundantly clear and to have, all of the legal obligations lined up with what you expect to happen, most importantly. Definitely super important, don't overlook legislation or obligations that you may have, legal obligations. By obligations, I mean, any legal obligations you may have to your spouse or dependents. And, legislation in particular you know, for example, if you move from one jurisdiction to another, like even from one province to another, there may be nuances between legislation that you need to think about. So super important. We're almost to the last step. So of course, we've done a lot of steps already. Now we're going to actually prepare your documents with your instructions all laid out in those documents. You do want to legally execute your wills and POAs. I know I mentioned this earlier. Most jurisdictions, the requirement is that it is signed, like wet signature, and then witnessed by two non-interested parties. So it shouldn't be, you know, your executor, it shouldn't be a beneficiary under your will or a spouse of a beneficiary under your will. That's really important. So you want to make sure that you properly do that. And if there's any supplementary documents, sometimes this gets overlooked. That, let's say, for example, you created your estate plan, and one of the recommendations for you to implement was to also update a beneficiary designation on a particular, registered plan or life insurance policy. You have to make sure that you actually fulfill that, if it's not going to be directly in your will and power of attorney documents. And this is so important. I can't stress this enough. Your original document needs to be accessible. And by accessible, I mean the location needs to be known, and access needs to be known. So if you do have it in a safety deposit box, your family should know that that safety deposit box exists. They should know that your will is in it. And it would be super helpful if there's a copy that they would have access to. Otherwise, it becomes a very strange loop of trying to prove to the bank that they should have access to the safety deposit box when they don't have the document that's in the safety deposit box that proves they need access. So definitely make sure that your original will is known. We get a lot of families that come to us and they're like, I don't know if my loved one ever did a will, and unfortunately, outside of Quebec, there's really not, there's a few online registries, but they're voluntary. So, it's unlikely that you would be able to find a will of a loved one if you didn't actually know where it is, right? And if the original can't be found, then, it could be as if it doesn't exist, unfortunately. So you have to really make sure that it's accessible. I mentioned this already. Don't use the ones named in your will as the witnesses. Don't forget the second witness. We see this too sometimes. You do need two in most jurisdictions, I believe all Canadian ones. And also, I've seen this a number of times. You want to make sure that you don't, if you want to make changes to your will, just grabbing them out from your filing cabinet and then just jotting down the changes on them is actually not a legally valid way to update your will. So if you do want to make changes to your will, you have to properly execute either a codicil, which is kind of a addendum to your will, or a new will entirely. So please make sure that you're doing that through the proper way. Lastly, as I alluded to earlier, it's really important that you communicate your plan to your loved ones. And I always say, have a family meeting, but I'll add a caveat, if you can, or if it's appropriate to, because I recognize that not all family dynamics allow for a productive family meeting. But generally speaking, I do encourage them because it helps everyone to, understand why you've maybe done things the way you've done them, and also gives them an opportunity to ask questions, right? And for you to give them the answers while you are here to do that, rather than them inferring, things later on down the road, right? Which might cause conflict and strain in your families. I mentioned this before, definitely inform your executor and POAs, any guardians or trustees, any alternates as well. You should always have alternates. Those are, the backup to all of your representatives if they can't act or aren't willing to act. And then always revisit. I I don't know why it says with any event. I guess that's not descriptive enough here. Sorry, but if there's any significant event that happens in your life, that's when you should really revisit your estate plan. For example, you get married or you get divorced. You have a new family member that's born, or even a loss of someone. An adopted family member. Anything like that, or a move from one jurisdiction to another. If you've received an inheritance, that's also probably a good time to revisit your estate plan, or any other type of significant change in your assets. But I would say a minimum of every 3 years. We do offer reviews at ClearEstate annually, but I would say a minimum of every 3 years. And that's not to say you have to change or update your plan every 3 years, but you take a look at it and you kind of recall or refresh your memory on why you did things the way that you did. And if all is still, the same and all still applies, then, there's no update needed, but at least revisit it. Definitely, all of those different life events I talked about, don't forget to align those changes that are in your circumstances in your estate plan. Overlooking jurisdiction, definitely a big one. And I'll add too, oftentimes people will overlook assets they actually have in other jurisdictions and not realize that they actually may need, a separate will. Like if you have a condo in Florida, you may actually want to have a Florida will to deal with that specific property to make your estate settlement much more streamlined. And lastly, I would say don't think of it as taboo to have these discussions with family members, with friends even. I think the more people talk about this stuff, the easier it gets to kind of understand, how we should do things and whether or not our plan makes sense for us. So that's what I would always kind of highlight. I think, we can take a couple of minutes here to talk about estate planning with ClearEstate, and then if there's questions, we can jump into questions. And I think here we're just highlighting again, estate planning, it can be quite complex and time consuming, hence, the overwhelm that I mentioned at the beginning. But a comprehensive estate plan is personalized to your needs, right? And takes account your particular goals and your particular circumstances, and is created to set your family up for success, right? Ellie, did you want to talk a little bit at all about ClearEstate's process?
Yeah, happy to do that. Thanks, Sarah. I can do this quickly, and please do drop your questions in while I'm going over this slide, everyone. We'd love to be able to address you specifically tonight while we have Sarah here. So yeah, we have a whole team of ClearEstate. We are actually 82 people at ClearEstate, and we're made up of, attorneys that are on staff with us, accountants, trust officers like Sarah, people who really do have the expertise that's required to take you through this process in a really easy to understand and manageable way. We're all about those small manageable steps as we bring you through the process. So the first thing is going to be that you're introduced to your team and led there by an estate professional, the person you're going to be interacting with here at ClearEstate throughout your journey. We do it in a series of meetings, and it's all done online like this. So you'll be meeting with us online, which is convenient, and a lot of people expect to be served this way these days, we find. So it's a nice fit there. The first meeting is going to be just intake of your information. So we want you to come prepared. You'll get access to our platform, and you're just going to put down all of your assets and liabilities. So your financial accounts, your insurance plans, things like that. We're also going to take information about who is going to be a part of your estate plan. Who are those people or entities that you want to be naming in your estate plan? After that first meeting, we go away and your estate professionals will look over your information to prepare for the next meeting, which is the guidance meeting. And that's where we're really taking you through the decision tree, all the questions and answers that we need you to address to really make a tailored estate plan for you. We'll explain the consequences of those decisions as well and give you guidance to make sure that it's going to be done in a personalized way and an efficient way for you in the future. After that meeting, we create your documents, we draft them, so your wills and your power of attorney documents. You get a chance to look them over, and then they're going to get notarized after that meeting. And finally, we'll securely store them for you. So they're going to be easy to find if you use ClearEstate. You're going to know where they are. And after that third meeting where we just kind of summarize, make sure everything's okay and good to go, we move you to the annual check-in schedule. So we'll check in with you once a year and say, here's your plan now. Has anything changed? Ask you a few questions to help you jog your memory after a long 365 days. And I think a theme, Sarah, that you touched on so many times tonight is that it's important to revisit it. So when you make a plan that worries more about tomorrow than the future, you need a plan that's going to continuously evolve with you throughout your lifetime. And ClearEstate does that with the annual review option. We make it easy and not overwhelming to continuously evolve as your life goes on.
Thanks, Ellie. That's great. I think I'll just highlight real quick the key takeaways that we want you to have today. Of course, you really need an effective estate plan that's mapped out carefully, that includes all of your pertinent information. And you should, of course, get the right help in order to actually get your plan done. And you should obviously get your correct legal documents done, of course, and then communicate and revisit. Those are really the key takeaways for you today. We can move on to a Q&A. Of course, wanted to highlight, of course, Michael and John will be happy to connect with you guys about any questions you might have, or if you want to know more about working with ClearEstate. We do offer free consultations. And I don't know if there are any questions, Ellie.
There's a couple good questions actually that I'd like to ask. So one of them is a pretty common question that we should get to, which is, how long have we been around? How can I be assured that ClearEstate will be here to help me in the future? Who owns it? Where's our headquarters? Things like that. Can we talk a bit about that?
Sure. Yeah, absolutely. So ClearEstate is certainly a relatively new company. We began in 2020, and I would say over a relatively short period of time have obviously grown significantly. We have more staff than most trust companies do, actually, and are processing more estate probate applications than most lawyers are as well. And I think that's because there is a real kind of gap in servicing out there available for folks who need help with estate planning and estate settlement, and want to do it in kind of a more convenient, I'll say, and modern way. In terms of who's behind ClearEstate, we do have a number of significant investors, including OMERS, National Bank, and also Torstar, to name a few. And I think what resonates with both our clients and investors and partners is really that our whole goal is to provide an online platform that also is backed by human subject matter experts. So that's kind of where we're coming from. Ellie, did I cover everything that you asked there, or?
Yeah, I think so. I'd say as well, in 2023, we've signed up 500 people for our estate planning services across North America. We've settled over 1,000 estates now. I think 1,600 are in process. So we continue to grow, and it's definitely a space that needed a shakeup, and people really appreciate our approach to this formerly antiquated process that we're really shedding light on and helping people through with a tech-forward approach, but really human-centered guidance as well.
Yeah, absolutely. And I'll just add one more thing that we didn't really touch on in today's session, but we do have a unique arrangement where we have access to a trust license to be able to provide the actual professional executor role for you as well. And that's something that typically is more often than not only accessible, from a trust company for, if your assets are, above a certain value, often inaccessible for a lot of families, whereas our pricing is about 1/3 of what they typically charge. So also important to kind of note that that's an option too, if there's questions as to who's the right kind of person, and if you need or want to consider a professional.
That's right. So we were able to act as the agent on the trust license of NatCan Trust Co. So all of the planning we do and is backed by them. So National Bank's trust arm, basically. We're the agent, we're going to do all of the work and they take on the liability. There's a question about government oversight. So I think it's important to state that everything we do is as agent on the trust license of NatCan Trust Co. And hopefully that answers your question. Another one is about how our fees are calculated. So we have several different levels of service. We have a setup fee to get you started and then an annual fee. That's just kind of your ongoing access to us and our platform and your annual check-in. So, you know, it depends on how much you need from us and we're going to match you carefully to the right service for you. But the prices start at around $1,200 to, for a couple, just over $4,500 to appoint us as a professional executor, which gets us set up at the beginning. A trust company like Bank Trust, they're going to charge between 4 and 5% to settle your estate. ClearEstate will charge 1% upon settlement. So it's definitely a different way of charging for these services, but it's a very easy to understand way and a huge savings, a big preservation of your wealth within your legacy in the future if you engage with ClearEstate as your professional executor. Can your, let's see, can your estate trustee work with or consult our named executor?
That's a great question. Yeah, I think so there's two options if I'm kind of understanding the question correctly. If you still want a family member to act as like basically they can be a co-executor with the professional, with ClearEstate, and that's actually a really good setup, I think, because then you guarantee the professional, like, you know, we're gonna carry out the burden of the administration and do the kind of heavy lifting, but that family member is going to be involved in the decision making. So that's one way you could deal with that. Another way is, you know, if you don't want the family member to actually be burdened with the decision making, you could treat them as a sort of informal consultant to the professional executor as well.
That's right. Okay. Think we've answered everyone's questions unless someone has one more. We still have 3 minutes to go here. Mike or John, would you like to jump in here?
Yeah, no, that's great. I think we'll end it here just to kind of keep us on track. Excuse me. I want to thank you, Sarah, for sharing with us your insights and thoughts when it comes to this very important topic of estate planning. Mike and I deal with this commonly. Obviously, a big part of what we do is managing money, but funny enough, one of the more engaging topics really is estate planning when it comes to our clients. So I'm glad that we've covered that off with this first session. You did an excellent job in covering some of the basic concepts of estate planning that commonly get overlooked, which was great. As Mike mentioned in his opening comments, this is going to be the first of what will be a few sessions on this important topic of estate planning. So stay tuned for some future invites where we can get a little bit deeper into some of the other concepts that you briefly mentioned today, such as trusts and stuff like that. I also want to thank Ellie for working with us and putting together this presentation. So thank you, Ellie. I appreciate that. Ellie, as our relationship manager with ClearEstate, has been working closely with both Mike and myself and the team. But in addition to that, she also has been working with many of our clients that have already started the work with ClearEstate in updating or completing their estate plan. And finally, I'd just like to take a moment and thank our clients and their families that have attended tonight's presentation. Hopefully you got some value in tonight's informative session. Having a complete and updated estate plan is one of the key elements of someone's overall financial plan and something that we stress quite commonly. There's still some questions that were coming in, which was great. So obviously a lot of engagement. Should any of you have any questions or want to get more information on just some simple topics of the estate plan that were covered today, or want us to do a little more of an in-depth review of your estate planning, even if it's one that's in place, but you want to recheck it, or if it's something that you need to do brand new, reach out to the office, myself or Mike. We'd love to set up an opportunity to chat with you at some point in the next few days. So again, just reach out. And on that note, I'll basically wish everyone a good evening